Hello and welcome. You're watching News Center. I am Ashmit Kumar. The Supreme Court has refused to prescribe timelines for governors and the President of India to clear bills passed by state legislatures. The five-judge bench today said that there is no concept of deemed assent. However, the top court signaled that limited judicial scrutiny may apply in cases of prolonged, unexplained and indefinite delay in granting of assent. The bench further clarified that the governor cannot withhold assent if a bill is passed for a second time without any amendments. The court also remarked that governors cannot act as super chief ministers, stressing that there cannot be two executives within the state. This comes after a rare presidential reference was made to the court over its verdict in April, which had imposed a 3-month deadline on dealing with bills that have been passed by state assemblies. To discuss this further, we have with us senior advocates, Mr. Dushyant Dave, Ms. Geeta Luthra, as well as DMK spokesperson Salem Dharani Rajan. We'll connect with all of them in just a bit. But first, we have Mr. Dushyant Dave with us. Mr. Dave, pleasure speaking to you once again. Thank you so much for joining us on CNBC-TV18. First, for the benefit of our viewers, if you could tell us the difference between a judgment and an opinion that has been given in a presidential reference like we saw today and the impact that it has. Are we now looking at a situation where the 3-month deadline that the Supreme Court gave in April stands overturned? Mr. Dave, I believe you've muted yourself.
Sorry. The difference between judgment and opinion is simple. Judgment is binding, the opinion is not. Opinion is given on a request by the president. He makes a reference to the Supreme Court and seeks the views of the Supreme Court. But be that as it may, the judgment definitely will have an impact on what was held earlier by Justice Pardiwala and Justice Mahadevan, in which they said that the governors are subject to the mandamus and that there is a time limit, and they prescribed a time limit of 3 months. To my mind, today's opinion is undemocratic, and it really runs completely contrary to the fundamental principle of parliamentary democracy, which applies both at the center and the states. The governors, or the president for that matter, are under the Constitution. They are not above the Constitution. Under our scheme, constitutional scheme, nobody is inferior in imperio. Everybody is under the law. And another aspect is very important, that every power which is vested on any authority, be it constitutional authority, judicial authority, or anybody else, the power must be exercised reasonably and within a reasonable time. And here, shockingly, Articles 153, 154, 163 and 200, if you read them together, there is no doubt in my mind that ultimately the democracy rests with the cabinet and the legislature. Once the legislature passes the bill and that bill is sent to the governor for assent, the governor has an obligation to approve, unless the governor in his discretion in certain cases may send it back to the legislature for reconsideration or may refer it to the president. And again, but that has to be done as soon as possible. The words which are used in Article 200 are as soon as possible. Now, you can't therefore say there is no time limit. I think this judgment opinion of the Supreme Court, to my mind, is unconstitutional. It runs against what has been held by the Supreme Court for last 77 years, that there is nothing called an unreviewable decision under our constitutional scheme. And it's therefore very surprising that judges have taken this view. I think I am deeply disappointed at today's opinion, because this really, lets loose a situation where parliamentary democracy, especially in states, will become, subject to, the discretion of the governor.
Sure.
And governor, therefore, will, in effect, hijack the democracy from the people through the legislature into himself, which is not really what was intended by the constitutional framers. After all, president and governor both are formal heads of the state, nothing more.
Fair enough. Let's also get Ms. Luthra in on this conversation. Ms. Luthra, again, Mr. Dave giving us a view that you cannot have two persons on the driving wheel. That appears to be a view that the Supreme Court also gave. Only it's unhappy with a 3-month deadline. Firstly, to begin with, give us a sense what happens to the April judgment which gave a 3-month deadline to the president and the governor. Do they still have a deadline? Is there a review of that judgment that is now required? How do we go about it? What is the law of the land? Is there a 3-month deadline?
See, the very fact that 3 judges have answered this fact that the reference has been answered, I feel that it really waters down that judgment which was given, which to my mind was the landmark judgment and which is the way to go. Because ultimately, it cannot be withheld without any reason and has to be decided as soon as possible. What is the role of the governor? We have a parliamentary system of democracy. In a parliamentary system of democracy, the governor's role is really very limited. He cannot be seen to be withholding bills. He cannot do this indefinitely. And to that extent, the judgment of the bench led by Justice Padiwala, which put a timeline, and it's not unknown that the courts have, in interpreting constitutional provisions and statutory provisions, read into a reasonable timeline. So my thought would be that that was welcome. And to that extent, this waters it down. Obviously, an opinion given by a larger bench in a presidential reference will have very weighty value to it. Now,
Sure.
It does water down that judgment. And for that, I can only say the court saying that it should not be unduly delayed. And as and when there is something which is completely unprecedented, you can approach the court. To my mind, it's a step backwards.
Right, Ms. Luthra. Mr. Dave, let me come back to you. At a time when Ms. Luthra as well is saying that, look, we've watered down the April judgment, which had given a 3-month deadline. What I want to ask you is that at a very conceptual level, the Supreme Court appears to be today saying that, look, we can't say that the president or the governor need to decide within 3 months' time, but at the same time, they should decide within a reasonable period of time. What the Supreme Court effectively appears to be saying that, look, I don't want to be very specific in telling you what you need to do, how you need to do it, but a broad range I can give you that within a reasonable time, if not 3 months, then maybe 3 to 6 months, it should be done. Are we muddying the waters? Is that a concern?
Let me tell you one more thing. The actions of the president and the governor are not like judges who sit over their judgment sometimes for months and years. I mean, and nobody can question these judges, why they are delaying their judgments. But here we are talking about in a state, a party with a majority has formed a government. It has its aims and objectives as they have been disclosed in the manifesto. It wants to achieve them because the electorate have elected them on the basis of those aims and objectives. It therefore brings certain bills. Now, bills are passed. If the governor is going to sit over them for even more than a week, according to me, why 3 months? Why 3 months? The governor must approve them as soon as possible. Maybe 24 hours, maybe a few days, maybe a week. But the whole purpose is that ultimately the people's voice has to be heard. And governor cannot stifle that voice by, sitting over these bills indefinitely, certainly not even for 3 months. Because, in a 5-year period that every legislature has, every day counts. The party in power wants to do something because it has been elected on certain promises. Now,
Right, Mr. Dave.
What we have seen, Ashmit, is something very startling. What has been happening since 2014 is that in BJP-run states...
Dave, I'll just interject there. You spoke of...
One more thing, Ashmit.
You spoke of the party... Yes, Mr. Dave, please go ahead.
This is happening more in opposition-run states. And that is a matter of sad commentary because the judges are blind to the fact that in BJP-run states, the governors approve the bills within a week or two. So why is it that you are allowing this situation to continue in opposition-run states? You can't, a governor, firstly, we are seeing that every governor is in an opposition-ruled state is acting.
So I'll just come in there, Mr. Dave. You spoke of the opposition-ruled states. And in fact, that's how this entire issue began, where the states of Kerala, Tamil Nadu, Punjab had to knock on the doors of the Supreme Court. And speaking of parties in power, we have with us Mr. Selam Dharanidharan, the spokesperson of the DMK. Mr. Selam, just again quickly, what is the takeaway for you here? You were celebrating when the Supreme Court had said that, look, there's a 3-month deadline, the governor needs to approve the bill within. Now, what are the legal consequences that you're looking at? What is the legal advice that you're getting? Are you looking at a situation where, again, the bills could be passed and you would not have enough clarity on when the governor would grant the assent?
The gubernatorial procrastination has been happening in all non-BJP rule state, and that is the problem. In a democracy, for example, in Tamil Nadu, 8.4 crore people of Tamil Nadu vote and select their member of legislative assembly. These MLAs in turn select the chief minister, and chief minister selects the state council of ministers. The state council of ministers and the legislator legislate. So where do we get the legitimacy from? We get the legitimacy from the people who voted us in power. So whatever we express, it is nothing but voice of the people of Tamil Nadu. So a bill that is passed in the legislature is nothing but that which represents the voice of the people. So if a governor is sitting on it for more than 6 months, 1 year, or sometimes on need 2 years, if you do a survey in Tamil Nadu, 95% of the people would say we don't want need, which is why we have passed a bill. But the governor has been sitting on it for 2 years or 2.5 years. So if a governor sits on a bill for more than 2 years or 2.5 years, which is more than 50% of the overall term limit, then it's a travesty to democracy, and that is a big problem. And already, if you read the Constitutional Assembly debates as well as the Constitution, it clearly says the governor should clear the bill within as soon as possible. So why have the governors been sitting on the bill inordinately? Because what is as soon as possible? For me, as soon as possible could be 5 minutes. For someone, as soon as possible could be 2 years, right? Which is why, because
that's a very pertinent point, right?
Because the constitutional framers did not set a time limit because they never expected people of low constitutional morality to hold the position of governors or presidents. That is a more interesting point. Only in the last 10 years, or 15 years, we have been seeing such governors.
Right, Mr. Selam. Right, Mr. Selam, I'll just have to come in there. That's a very pertinent point that you raise. What is a reasonable time? The Supreme Court's view is we can't give you a specific timeline, but we want it to be done within a reasonable time.
No, 10 seconds.
Yes,
10
Mr.
seconds.
Selam.
I just need to add on.
Yes, Mr.
So
Selam.
when they said 3 months, it was an extraordinarily good judgment. But now again by saying you can't inordinately sit on a bill, what do you mean by how long is inordinate? 5 years, 10 years, 15 years,
Which is the very question.
20 years?
Let's take that question across. Let's take that question across to the legal experts that we have. Ms. Luthra, coming to you. This quandary that the Apex Court has now, the Supreme Court has now left us with, that the governor needs to act within a reasonable time. What is a reasonable time? There are cases where bills were pending for over 2 years. Is that unreasonable? Is a 3-month wait unreasonable? How do we now look at the Supreme Court deciding on a case-to-case basis that, look, in this case, this is a reasonable time, 2 months is a reasonable time, 6 months is a reasonable time? How do we go about answering this question? What is reasonable? Ms. Luthra.
See, this was the most brilliant opportunity for the court to show its mind as to what is a reasonable time. To my mind, a week or 2 weeks, unless the bill is very complicated, is a reasonable time. Ultimately, a governor is really a titular authority. The governor's role is only to act on the advice of the Council of Ministers. So he has this authority and the power under Article 200. But as soon as possible, even say in suits of specific performance, are saying 2 months. I think even that is too long. There may be a bill which was crying, which may be part of the manifesto of a party. And it's crying for being decided one way or the other. So the governor cannot but act with great expedition. And I would have thought that in the reference, this opportunity of setting things right or laying guidelines, because why do we have 3 wings of governance.
So an
Why do we
opportunity
have-
lost, Ms. Luthra, is how you're
Yes.
describing this opinion that the Supreme Court has given. We're running out of time. Mr. Dave, I'll come to you for the quick closing comment. Do you see a silver lining? What happens to parties like the DMK who are ruling in Tamil Nadu? What happens to them? We've seen previously that they had to knock on the doors of the Supreme Court. Has that door been kept open by the Supreme Court giving an opinion that the governor needs to act without inordinate delays, and that is the open door for opposition ruled governments to actually come to the apex court and say that, look, we need relief, we need our bills to be passed? Is that a legal remedy, a legal relief that is now available to opposition ruled states?
I think the judgment sounds death knell on parliamentary democracy. And it's really a sad commentary on Supreme Court that it has lost opportunity, as Ms. Luthra rightly points out. If you look at Article 154 or 163, both say that governor shall act as per the Constitution and shall act as per the advice of the Council of Ministers. These are words mandatorily used. So, principle of constitutionalism requires governor to act as quickly as possible. And if the governor does not, then Supreme Court is wrong in saying reasonable period, because reasonable period is a completely vague term. So to my mind, Supreme Court's judgment is most unfortunate, although I must confess that I did expect this opinion from the 5 judges.
Strong language there, Mr. Dave, but I'd like to thank all of our panelists for joining us and sharing their perspective. Ms. Luthra, Mr. Dave, Mr. Salem, thank you so much for sharing insights on what was, again, a landmark opinion that the Supreme Court has given with respect to the powers of the governors, the conduct of the governor as well as the president. The Supreme Court doing a balancing act, trying to say that on one hand, you can't have a 3-month deadline being given to them, but in the same breath saying that they need to act within a reasonable period of time. That's unfortunately all the time that we have. We're heading into a very short break. We'll continue and bring you more. And this is on AI. AI has been all the buzz. But what about safety? I spoke with Evan Kotsovinos, VP of Security at Google, who says that deepfakes are the biggest challenge. That interview is coming up shortly.